be mindful of what is out there, both on a government level, whether it's federal or state, and make sure that you've done your own risk management assessment of your workplace and of your clientele. And then put those policies in place, make sure they're widely distributed, and always implement them consistently.
You are listening to Legal Skinny Podcast with Trisha Barita. I'm a 15-year licensed practicing attorney in the state of Texas. I created Legal Skinny because when I've been invited to do educational seminars on different subjects in employment law, employers and HR professionals would often ask me, where can they find out a little more information on this or a little more information on that? Look, there's a lot of resources out there, but sometimes it's confusing and people are so busy. Sometimes people have only 30 or 15 or maybe even 5 minutes in their day to devote to learning something new. On this podcast, you'll hear me have discussions and interviews on topics relevant to employers. Disclaimer though, Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you. Private employers are continuing to assess their level of risk as coronavirus continues to spread across the United States and globally. And nobody wants employees that get exposed while on travel or during other off-duty personal activities to bring coronavirus into the workplace and cause an outbreak of infections. While we have seen a lot of various travel restrictions across the world from country to country, we've also seen state-by-state restrictions and at some level even county-to-county restrictions imposed in attempts to thwart the spread of this coronavirus. Early on in the pandemic, the state of Texas's Governor Greg Abbott imposed quite a few travel restrictions and requirements for quarantines for visitors or returning Texans from various states across the United States, which expired back in May during Texas's reopening. But now New York has emerged more recently, as well as several other states, in naming visitors or individuals traveling from certain states that are required to quarantine upon return. But where does all this leave employers with how to address these quarantine issues with employees? How far can an employer go with requesting quarantine of an employee or to request employees cancel personal trips or postpone non-essential business travel? Today, my guest is both a friend and colleague, Lisa Coppola. Lisa is a 31-year licensed practicing attorney and owner of her own law firm, the Coppola Firm, that does work across New York State. Her legal practice includes defense of businesses on the employment management side, business litigation, and personal injury matters. Since this episode is New York State of Quarantine, I knew Lisa being in New York could help me weigh in on what has been going on with these quarantine restrictions during the COVID-19 pandemic and how quarantine affects employers with employees' travel and other activities conducted personally and for work. We had a great chat on these issues, so I hope you enjoy Legal Skinny Podcast, New York State of Quarantine. Welcome, Lisa. Thanks for joining the Legal Skinny Podcast. How are you doing today?
Doing great. Delighted to be here with you.
All right. Can you give us a little background on your work?
Absolutely. So I'm a serial entrepreneur up here in New York State. I own right now a garden design and construction firm and a law firm. I've been in practice 30 years, and we have a variety of matters we deal with, but one of my favorites is the area of labor and employment law.
I love that, a serial entrepreneur.
It's a lot of fun running businesses, lots of challenges, but a ton of fun.
Yeah, I feel like a lot of entrepreneurs are always looking for the next thing, even if they the sell or get out of the business they're in. It can be quite of an addictive type thing.
For sure.
All right, so you and I have known each other, been friends for quite a while, of course, pre COVID-19 pandemic. And as you know, I have some family in New York, and so like most of America, I was watching closely as New York really took center stage early on in the COVID-19 pandemic, several months ago, of course. So can you take me back to March and April and kind of give me, your experience and what was going on in kind of your words?
Yeah, it's so fascinating. March 15th, the Ides of March and Julius Caesar, and it sort of seemed like that all culminated with the world in New York State kind of coming to a screeching stop mid-March. We saw, incredible numbers of COVID-19 in the Manhattan area and also throughout the state. And so it really required us in the law business to stop on a dime, to be super flexible, and required lots of businesses to do that. We mobilized immediately, most of us from our home offices, because virtually all businesses, except for essential businesses, were told they can't work in a commercial setting. It was crazy for a while there.
Yeah, I know. It's been a really difficult time. A lot of people, were heavily suffering both economically and, of course, from the COVID-19, condition, or family members or employees having them. Back then, Texas actually had a travel restriction that Governor Abbott's executive order put in place, requiring a mandatory quarantine of a number of states, which New York made the list. It also is a state of California, state of Connecticut, state of New Jersey, state of Washington, city of Atlanta, Georgia, city of Chicago, Illinois, city of Detroit, Michigan, or city of Miami, Florida. Now, that kind of all sort of started around March 29th and continued through into April, with then the restrictions being lifted when, Texas was looking at being one of the first states to open up on May 21st, 2020. Those restrictions, the governor lifted in another executive order. So I jokingly referred to these lists, these travel restrictions, as the naughty list for travel. Now it's a joke, but in turn, Texans shouldn't be surprised that now they're on the naughty list for travel, for some other states, including New York. So can you tell me a little bit about what happens if, if anyone is returning from one of these states that's on this sort of naughty list for travel, and including
Sure.
if my fellow Texans and I attempt to go to New York, what exactly might happen?
Right. So New York, it's interesting. New York, New Jersey, and Connecticut have worked collaboratively together, which is really terrific to see that sort of collegiality among states that are in close proximity to each other. And so New York has the list that's shared by these other states of locations from which travelers will come, and they are required to quarantine for 14 days if they choose to come into New York. And interestingly enough, it affects things like travel of New Yorkers. So if a New Yorker went to Texas, which happens to be on, I love your naughty list, Texas is on the naughty list. So if one of us want to come down and visit Houston or Dallas or Austin, and then we come back to New York State, we also must quarantine. Right now, there are 19 states on this list. So Texas isn't alone there. And essentially what we're looking at is a 7-day rolling average. So for a state to get on the New York list, the naughty list. Yeah. Over a 7-day rolling average, the state has positive tests in excess of 10%. So positive COVID-19 tests in excess of 10%, or the number of positive cases exceed or are greater than 10 for every 100,000 in population. So that list has been changing. Our governor changes it and it's available on the internet, but it causes all of us to take pause, other than so-called essential workers. So there is a carve out for essential workers if they are traveling into New York to help, for example, with the pandemic, or if essential workers leave New York, and some of us are calling that a loophole. So if an essential worker simply wants to leave New York to go on vacation and then come back to New York, they don't have to quarantine. And some are questioning whether that's fair for sort of purely recreational or social travel. But in any event, we've got this quarantine in place. It calls for the governor and the government to assign fines if someone is found to not quarantine. And if they cause harm, that's the standard, there's up to a $10,000 fine to be applied. So it's going to be interesting to see how this develops as different states become what we're all calling hotspots, right?
Yeah, as far as the essential worker is, are you aware of if New York defines that like similar to I think the 16 categories in the critical infrastructure, or is there a different standard that they're looking at for that?
Yeah, New York's created its own standard. The governor, in one of his earliest executive orders, defined essential work, and then anyone who works in or supports essential work is considered an essential worker. It is arguably broader than the federal standard. So it encompasses quite a number of different types of employees. I'll give you an example. We all believe, of course, that medical professionals are essential workers, right?
Sure.
But if somebody's working in a consultancy, for example, doing billing or doing coding for a medical practice, because that person supports an essential business, that person also is considered an essential worker. So lots of support for other essential businesses. If you support banking, which is an essential business, if you support construction that helps with the military or defense, then you're considered an essential worker. So it's rather broad.
Yeah, that's interesting. So I think I read somewhere too where there are some New Yorkers that, I hate to say the word fled, but chose to remove themselves from New York during the high time of the COVID-19 pandemic for New York, and have been frustrated with returning because they are now in one of these 19 naughty list, travel list states. And, they're just trying to get back into their house or condo or apartment, especially some that are trying to get back into the city of New York. It's still, there's no exception that if you're a New Yorker, right? I mean, even if you're a New Yorker, you go out, like you're saying, unless you fall under these essential workers, you're still expected to quarantine. You're still subject to these fines. Is that right?
That's absolutely right. We have an enormous population of what we call snowbirds, right? We're up in the Northeast, so winter can be challenging up here. And great swaths of our populations head to Florida, head to Arizona, head to southern states for the winter. And those are exactly the people you're talking about, Trisha. They want to come home. It gets warm here. We were joking, it's getting towards 90 in the woods today. And so our snowbirds want to come home, but there is no exception even if they're resident of New York State, when they come back from one of these states that have some significant COVID-19 numbers, they're required to quarantine for 14 days. No question about it.
Very interesting, and I'm sure frustrating to those to your fellow New Yorkers in that realm and trying to figure that out. The little bit about, like, if you're on a plane, you fly into New York, do you know anything about exactly what's supposed to happen? When I was looking back at the governor Greg Abbott's order of Texas, when he sort of implemented his quarantine list, he had that individuals would be filling out forms upon disembarkment. And then that would be then the DPS troopers or other peace officers would take these forms from the individuals that are coming from one of these states or cities, and then verify it against the driver's license or passport, and I guess determine whether or not the individual is expected to quarantine. Is New York kind of doing something similar to that?
It's very interesting. New York doesn't have detailed guidance on how the state or how state enforcement officers might act upon arrival. So we're not seeing that happening the way your Governor Abbott handled things a couple of months ago. Rather, our state enforcement mechanism, although government actors have the right to enforce, we just don't have the practical implementation here. Rather, what we're seeing in our guidance is that folks are being asked essentially to report violation. And so there are forms available for reporting, reporting neighbors and colleagues, I suppose.
Oh gosh.
Yeah, right. It's a very interesting scenario, but I think everybody is of course sensitive to making sure that the public health takes priority here.
Yeah, I could see that. So let's kind of switch gears and talk a little bit about, now that, we've seen these kind of restrictions, both our states have implemented or currently have them, or, although my state obviously has taken some of those back when they opened up, but how employers should be handling this. I mean, when can an employer require workers to self-quarantine? When I'm kind of looking at this, I feel like there's some clear guidance, and then there's these real murky gray areas, and kind of like, what should employers do? Obviously, I feel like this is always what, because, we both practice in the area of labor and employment law. I feel like the employers often want to go into the gray, murky area just willingly. Like, they're just like, let's wade in there. Right. It seems to be, of course, one of the key issues as to how they try to solve problems is wade into that gray, murky area. So let's talk a little bit about like what you think, if you have any thoughts on the clear guidance and the gray, murky.
Yeah, absolutely. So, we in New York had some emergency legislation passed back in March, a special COVID paid family leave law. So in addition to the federal leave laws that were put in place at the end of March, we've also got this New York State law. So our employers have some pretty clear guidance about how to address quarantine, how to address people who need time off. But it's so important for them to have their own very clear, very transparent, and consistently applied policies in place. And I'll tell you, I mean, we're now in July. For the past, 3 months, we have been writing policies nonstop for our employer clients. And, we made sure that they had in place not only policies dealing with quarantine and leave and whether it's paid and whether it's unpaid, but also things like working at home and confidentiality and all of that. So these gray areas, I think that as we approach them, I think the best approach we as lawyers can take is encouraging our clients to do that piece of preventative medicine, get those policies in place so that they can apply them and not be accused of taking action that's improper or discriminatory or things like that.
Yeah, I think I can totally understand, agree with where you're coming from with that, because of course, so the pieces of the Families First Coronavirus Response Act, the federal piece, and I see what you're saying that New York has and other states probably also have potential state legislation or already had paid sick leave laws in place. In that kind of realm, they built in with the FFCRA when it was implemented April 1st. If you have a required government order or advice by employee's healthcare provider, which sometimes can come from related to travel or other reasons of being exposed to a COVID-19 employee or other individual, allows for this sort of quarantine mechanism. And so that would be a place, of course, where there would be, I think, seeing some clear guidance that employers can be restrictive about wanting to know and requiring some type of quarantine if an individual falls under that. And then, of course, the FFCRA, if they haven't used it up, would allow for some paid sick leave in that potential opportunity when the employer is making that choice. But
I think that's right. Yep.
Yeah, I guess the key, right, would be when we get into that gray area of when we don't have a government order, we don't have an employee's healthcare provider, and then having the policies around what you do with that. Like where can you go with that? Employee takes vacation out of state. Maybe it's not in one of these, like for instance, Texas doesn't have any travel restrictions right now, even though as I just read, they had quite a few. So, if someone goes and travels to, Florida, which has quite a few COVID-19 cases right now, comes back, what can the employer do when they don't have that order in place? And I think that's kind of tricky. How much can they restrict that? Some companies are trying to create policies around that. What are your thoughts on that?
Yeah, I think it is tricky, and it requires a fair amount of thought in advance, even in these changing times. And what we like to talk about is, what is the nature of the workplace? So here's an example. When you work in an area where you might have a vulnerable population as your clients, physicians' offices, for example, we've worked with folks and talked about, how do you want to protect not only your staff, because great employers want to make sure their people, their teams stay healthy. Great employers also need to be particularly attentive to who their customers are. Are they coming in? Are they sick? Are they vulnerable populations? And what we find here in New York, and it may differ in other states, is that businesses can have in place policies that require quarantine, even if there isn't an order in place from a government like a New York or a Texas. So policies, as long as they are clear and transparent and non-discriminatory, right? They can require quarantine if somebody in your instance went to a hotspot state and then came back in, or went to a hotspot city even and came back home. So we're seeing a lot of businesses take this very seriously. Whether the leave is paid or not comes down to not only these laws, both state laws and federal laws, but also comes down to the employer's sick leave policies, PTO policies. We've put in place, for example, quite a bit of COVID-specific amendments to leave policies. So some of our employer clients want to be more generous, where PTO might not be allowed for a particular reason. They're opening it up to their people to make sure that everybody is focused on taking care of their health, and making sure that if there's a question about whether they might have been exposed, they're not coming in and exposing others.
Yeah, I think that's a great point. Would you say also, in implementation of such policies, of however the employer does go forward with them, making sure that they're actually implemented in a non-discriminatory manner, that you're treating everyone the same way?
Absolutely. So that's, it's a significant issue, right? You as employers, we've got to be absolutely, I would call it vanilla about how we apply our policies. We can't, because somebody might be particularly important to our business, we can't say, well, we won't apply the policy to that person because we really need Sammy to come back to work. No, we've got to apply those policies consistently across the board, because, well, one, it's the right thing to do. And two, we don't want to walk into some potential legal liability because we've failed to consistently apply or implement policies. And so education's huge. When we work with business owners, we're consistently encouraging them to make sure their managers understand the policies, so that managers, because their managers are usually the first line, right, who get asked questions. So the managers understand it and then can convey the information accurately and consistently to all the employees too. This has become a burden for employers. There's no question about it. But the more they can educate their people to understand that what they're trying to do is make sure public health is a primary concern, then I think they come out of it at the other end, gaining not only the understanding of their teams, but also the loyalty of their teams. And we can't forget that, in the midst of this, we can't forget employee morale as well.
Yeah, I think you're spot on with that. As they delve into, what type of potential restrictions, if any, an employer, and they say they go into the gray or murky, or maybe what, based on state law, you may feel there's some more clearer guidelines. But how far can they go? I kind of wonder myself, looking at this, as you see these restrictions right now, it's under travel. Are we going to see it under risky behavior? Do you need to disclose that, someday, baseball might get started again, or God forbid, the football season, and people are fans. Yeah. They want to get out there, and that could be considered really risky behavior. So is the employer going to require, are they going to have those means? Does it start to get slippery slope? I think that's a little confusing, right? And once you kind of go in there and start asking all these other different questions, it's like what you just said, everyone's got to be treated the same. So you can't be like, well, the employee that is, the high level key employee, is doing all these risky behaviors, and we're going to accept that, which could clearly walk you into sort of a disparate treatment of another individual that, maybe also did those risky behaviors, and the employer's frustrated with them taking that action. What do you think?
Yeah, without a doubt. At the risk of sounding, like employers should always be consulting with their legal counsel, this is an area where employers should be consulting with their legal counsel, because there will come a time when the questions become too intrusive, right? Where our, government, whether it's federal or state government, says, no, you really can't ask that question, right? What did you do Saturday night, right? Typically that's off base. We can't ask those questions of our people in the workplace. But given the public health issues relating to the pandemic, the federal government for sure has loosened up the ability for employers to ask questions. But I still think it comes down to a case-by-case scenario, and good legal counsel is an employer's best friend these days.
Yeah, I think that speaking of which, kind of, we as far as whether or not, there can be some question asked, we've gotten a little guidance from the EOC. I know that you and I are both familiar with this, but I'll just mention it for anyone listening, that when the EOC guidance came out for the Pandemic Preparedness in the Workplace and the Americans with Disabilities Act, which is basically, if you're an employer subject to the Americans with Disabilities Act, when the CDC declared that COVID-19 was a pandemic, the EEOC came out with this other set of guidance that will now sort of shift the rules. Now, of course, they've said clearly, once the CDC pulls back that there's no longer a pandemic related to COVID-19, then, the regular rules then would probably come back into play. But during these, pandemic rules, they did kind of address, the issue related to travel, at least, maybe not football games and baseball games and other, potentially risky activities. But when an employee returns from travel during a pandemic, must an employer wait until the employee develops influenza symptoms to ask questions about exposure to pandemic influenza during the trip? The EOC said no, these would not be disability-related inquiries if the CDC or state or local public health officials recommend that people who visited specific locations remain at home for several days until it's clear they do not have pandemic influenza symptoms. An employer may ask whether employees are returning from these locations, even if the travel was personal. What are your thoughts on that? Have you seen that being used?
Absolutely. I think it's used widely here in New York. We're seeing and we're creating policies and disclosure forms that call for this sort of information from employees. We're asking them, and we're allowed to do that under the law. We're asking them, where have they traveled? We're asking them to tell us, truthfully where they've been and if they've gone outside of the particular approved area. And for some employers, they're comfortable with our governor's naughty list. So if you head to a state that you must quarantine, then the employer's policy is going to say that. But other employers, as I was mentioning earlier, that might tend to particularly vulnerable populations of clients or patients, certainly in the healthcare arena, we see this a fair bit. If somebody travels even within our New York state, the policy may say, if you've traveled outside of several counties, please tell us that. And if that's the case, we need you to stay home to make sure you're not an asymptomatic carrier, right? I mean, that's one of the issues we've seen come up from the scientists is it's not just folks with symptoms who might pass the virus on to others, but it's asymptomatic folks. So we're seeing a lot of these policies. We think they're really smart business because, and it's not certainly a topic for labor and employment attorneys, but there could be claims made later. There could be claims made by employees or customers or clients that, well, you allowed somebody to come to work who could have been sick because they went to a naughty list state.
Because they went to Texas.
Because they went to Texas.
Jeez.
Right? And so businesses have to be mindful of those risk management issues.
And as they kind of try to figure out the policy issues, I think we should note, right, that, if the employee is covered by a union or has employment contracts, that may play into this too, right?
Without a doubt. Sure. Collective bargaining agreements govern the relationship between employer and employee. So generally what I'm talking about is at-will employment when there's not a contract involved. But certainly I know that our union colleagues are just as concerned about public health as, the management side of the equation is these days. So hopefully they could work collaboratively on ways to ensure the workplace remains safe.
Yeah, I think we've seen that play out, particularly in the professional sports realm, where
right.
The players' unions versus the leagues trying to figure things out. But what if an employee takes a vacation or is on has just off-duty work, and if you restrict the employee too much, do you have any thoughts, Lisa, on is that going to get you in trouble with the FLSA, the Fair Labor Standards Act, the Department of Labor? Should you if you put too many restrictions on them, is it going to be considered where they're on call almost?
Right. And there are concerns about that under the federal law, and some states have those sorts of on-call laws as well, including my state here in New York. So again, it takes a lot of thought, right?
So be wary.
Be wary. Right?
Don't think you can just lock that employee up in a box and say, hey, you can't do anything.
Stay home, don't leave your bedroom. Right. We can't do that. We've got to make sure we're being mindful of all those pre-COVID laws because they haven't gone away. Right.
I feel like employers are so scared that the workforce is going to completely they just got, maybe back open. They have an economical issue. They're trying to have jobs for people. And now, they don't want the whole workforce to go down. So there is this sort of like anxiety to, prevent the spread, as well as try to figure out kind of what the right thing to do is. And, sometimes you forget, those other laws are still there. And the Department of Labor I've been watching is still right on there enforcing those.
Oh, yes, they are. Yes, they are.
Yeah.
And so, right. It's, as we've been saying, it's a big challenge for business people and employers to really navigate these murky and roiling waters. There's a lot to consider.
And when you're looking at, before you shift into something that's that I've seen in some news stories recently, just to clarify, quarantine is a little different than the stay-at-home or shelter-in-place orders some of the states have put in place, right? I mean, if you're quarantining an employee, there's or state or local guidance is quarantine, they're expecting you to stay home, right?
Yeah, that's right. There are very clear rules and regulations around this. Usually it's a Department of Health, either a state or a local Department of Health will list what quarantine means. And for many, if not most people in the COVID arena, it means not only stay at home, but also isolate from other members of your family, always be masked up, use separate bathroom facilities, don't take family meals, have food delivered, and stay in a particular location of your home where other people are not allowed. So this isn't just don't come to work. This isn't, you can go out and play a game of tennis. Quarantine is serious business.
Yeah, but if they can quarantine and they are asymptomatic and they have an ability to telework, they still get paid, right? I mean, there's still a way for an employer to find a solution to this.
Absolutely. And there are so many kinds of industries and professions where employees can telework if they're up to it, if they're, as you say, asymptomatic, if they're not experiencing any sort of debilitating symptoms. It can be in large measure business as usual, just in a remote way.
Yeah. If they're entitled, of course, to FFCRA, then the employer will just have to sort of work that out with whether the employee, they want to use that time then or save it for potentially if they get infected or some other qualifying reason. But that's kind of an employer can kind of work that out. Now, I kind of want to switch gears to ask you about a news story I saw the other day, which was a little particularly disturbing, where an employee was arrested for allegedly creating 2 documents forging a county health services director's signature. One of the documents was stating that they were required to participate in a 14-day quarantine. And then the other one was the release document. These actually were modified off of real documents. So the individuals that gave this person the document or allegedly gave it to them also got in trouble. I feel like this adds a whole other layer of what employers have to be thoughtful about, this issue of fraud.
Yeah, it's pretty disturbing. And if I can editorialize for a second, it's reprehensible. There are real people suffering from this virus, and for somebody to take it upon herself or himself to sort of fake it, to try to get time off from work, it's really unacceptable set of circumstances. So employers, without being skeptics about everything, certainly it's incumbent on them to ask questions within reason. We're seeing a lot of this in New York, in my part of the country.
Oh, really?
Yeah, and it's very unfortunate. So our we see it in unemployment as well. We've been asked to report when we think that somebody is declining to return to work for an inappropriate reason. They're lying about it. And there should be situations where folks are held to account if they're committing fraud, because that just, it hurts all of the honest employees and employers across the state or even across the country. In a situation like this where somebody faked, a quarantine order, my view is termination is an appropriate consequence to that. If, for example, the employer relied on that fraudulent document for FFCRA leave, for example, and took the withholding tax credits, does that make the employer a party to that fraud, right?
Good point. I mean, I think if they go along with it, it could. That's the same with unemployment. Texas is having the same thing. I'm seeing, that the Unemployment Commission here is starting to investigate these potential, fraudulent claims related to unemployment. I think employers, could get in trouble if they are helping employees get unemployment where it is not appropriate for whatever reason. That those fraud claims are real. There's civil and criminal penalties here for that. I don't know if there is in New York, I'm sure.
Yes, absolutely. Yeah.
And sometimes that's confusing because, some employers have these close relationships with their employees. They want them to, but they want them to get, paid, but crossing that line to where, it maybe isn't appropriate. Now, of course, there's clear guidelines on what's appropriate with unemployment. I think the Unemployment Commission's, God bless them, have been completely overwhelmed across the United States. It's for all those workers, it's been a really tough job trying to work through the many calls, probably people angry with them, employers frustrated, employees frustrated with the process. Certainly They didn't anticipate this. Many, at least over here in Texas, the commission, at some point they were struggling to answer any phone calls, and try to respond to particular issues, which I think is why now things have calmed down somewhat and they're trying to do these investigations of fraud. But employers being conscious of that is important, right?
Absolutely. And, we have a sort of a blanket policy. If you're offering a return to work to employees, make sure to document that, make sure to do it in writing. Even, printing out an email or a text helps document that. And if the employee refuses to come back, contemporaneously or at the same time, document that as well so that your records are very clear. Because again, the employer doesn't want to inadvertently or unknowingly walk into liability that a government, enforcement bureau or enforcement agency might question that employer.
I love that. That's great. Great stuff. Information there, Lisa. So looking forward here, all right. I feel like we've talked about a lot of things related to quarantine, what quarantine is, the fraud, the other issues, the gray marquee, the clear guidance. But if quarantine is going to be a continued method, right, to combat COVID-19 or to reduce the spread of COVID-19, at least from the government's perspective and the local, the federal, state guidance, they're going to keep changing these regions. I talked with someone else about whether or not, at some point we may see full federal guidance on, what the standards are as far as, restricting travel. But regardless, right now it's sort of like a quilt, a patchwork of trying to keep up with this. How do you see this going? Do you think employers are going to be expected later on to have really paid attention to which states are quarantining who?
Well, I think employers need to be mindful that it's out there, right? And if on a state-by-state basis, there is information, I would say employers, in their human resources functions should at least periodically monitor those so-called naughty lists, right? And know it. But ultimately, a policy making it the employee's burden to understand what is either within an approved range of geography or outside of an approved range of geography is perfectly acceptable. It would be okay to do that in my state, again, absent a collective bargaining agreement, to tell employees in a policy, you have the obligation to review the governor's executive order, the Department of Health's identification of what states, right now there's 19. Maybe it'll be reduced a little bit, but maybe some other states might be added across time periods, right? You've got that obligation. And then when you return to the workplace, you have the obligation to certify truthfully where you were. And if you were in one of those places where quarantine is required by law or quarantine is required by an employer's policy, then you've got to follow that. So I think it's a collective responsibility, right? Employer, employee, it's always better if there's open communication and there's cooperation there. But ultimately, if the employee is the one doing the traveling, right, there has to be some responsibility on the part of that employee to make sure he or she knows what the consequences of those decisions might be.
Yeah, knows about those naughty lists.
Yes. Indeed.
That's what you'll be calling them, Lisa, after today.
Now New York has a naughty list. I love it. It's great. If you don't mind, borrow it.
Go ahead, take it, steal it. I love it. This is obviously great information. I can't thank you enough for taking the time joining me here today. Before we wrap up, do you mind if we do the legal skinny rundown?
Yeah, would love to.
Okay. All right. Beach or mountains?
Mountains every day.
Elvis or the Beatles?
Oh, the Beatles.
Most influential book you've read?
Honestly, from a Texan, Brene Brown, a book called Daring Greatly.
Love it. Dead or alive, which famous person would you invite to dinner?
I think it would be Glennon Doyle, who runs a charity called Together Rising.
Very interesting.
Yep.
All right. Finally, in 1 minute or less, what is the skinny on quarantine during COVID-19 for employers?
The skinny on quarantine is be mindful of what is out there, both on a government level, whether it's federal or state, and make sure that you've done your own risk management assessment of your workplace and of your clientele. And then put those policies in place, make sure they're widely distributed, and always implement them consistently.
Love that. So if someone wants to get in touch with you, what's the best way for them to do that?
Oh, I'd love to hear from them. They can email me. The easiest email is info@coppola-firm.com. or give a call up here in New York State, 716-839-9700.
Now they don't have to quarantine just for calling, right?
No, you can call at will.
All right, thanks again, Lisa. And that's the Legal Skinny on the New York State of Quarantine. Thanks for joining us on this episode of the Legal Skinny podcast. Do not forget to subscribe to get future podcast episodes. Also, check out legalskinny.com to join our newsletter and get details on all the educational resources we offer for the employer. Also, disclaimer, remember, Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Laws change or they differ by jurisdiction, so also remember this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.